Um, Good afternoon, everyone. My name is Mugdha Lele, and on behalf of the TechX team at Venture Center, I'm happy to host the third wave of the Only One Thing Awareness Talk series on innovation management. Today is the second talk in this ongoing talk series, and today's topic of discussion is protecting and licensing music. Our speaker for today is Dakshayani Athalye. Let me briefly Let me briefly introduce Dakshayani before we begin the talk. Dakshayani is a singer, writer, and a lifelong student of Indian philosophy. She has a master's degree from Tata Institute of Social Sciences, and she studied law at the ILS Law College in Pune. Currently, as a CEO of the Baidak Foundation, her work focuses on building a resilient organization that prioritizes self-reflection, self-change, and social action. Her vision is to revolutionize access to traditional music and dance immersion and education in India with a special focus on children from underprivileged backgrounds. The most important aspect of Dakshayani's work is that she is passionate about safeguarding music and ensuring fair licensing practices, and that is what she's going to focus on in today's talk. So, with this brief introduction, welcome Dakshayani to the session and handing over the session to you. You will have to unmute yourself.
Yes, I could do that. Thank you very much, Mugdha, for the for the generous introduction. And I'm happy to be present here. I mean, though a lot has been said in the introduction itself, I would humbly submit that I'm only a student of law and I'm also only a student of music. So whatever I will speak today will be from those experiences as a student. And I'm sure that there may be many more experts, of course, outside who will have maybe even more nuanced perspectives on what I will be primarily speaking about today. Before we begin, I actually wanted to, and I hope that's okay, Mugdha, if we do it this a little differently. I don't want to start off with the presentation and the usual description of the law. I actually would like to start off with some bit of participation from all the members who are present here. I wanted to understand, if we could, in the chat box, put maybe one question that bothers us as regards music licensing, as regards copywriting music. If there is one question that you all can put in the chat box, that will be very helpful, because I will be able to then anchor the entire discussion around those questions that we have in the audience today. Yeah. So if that's possible, I was thinking maybe we could take just 30 seconds to drop a question.
Yeah, sure. People, the chat box is open, so please put in your questions there. And Dakshini, I hope you're able to see the chat box also. Are you? So there are three dots on the right where you'll get the chat option.
Yeah, I'll just look for it.
Three dots under more and three dots at work. Or even in the lower panel, there is a chat option.
Yeah, I can see that. Yeah. I'm just trying to switch from direct messages to general messages. I hope everybody is able to send those messages too.
Yeah, so we already have questions coming in.
Yes. Okay. Thank you, Premnath, for the question. Yeah, please, if we can have some more questions, I will see if I can answer those in the discussion. Was it fair to use someone's music publicly? Thank you, Mahi. How to prevent music copyrights from being infringed? Great. Thank you, Kavita. Okay, how do you identify copyrighted music? Okay. Thank you, Pramodini. While protecting music? Thank you, Pooja. Thank you, Nirali. Very interesting questions.
Yeah, I
Maybe
think probably there are quite a
yeah.
few questions now
Yes,
for you
now
to
we can.
answer around.
Yes, that is perfect. For a specific region, what legal challenges arise? Country. Yes, perfect. Okay, this is very helpful because this will help get me my speech anchored. Now I will share the presentation. I don't actually have a long presentation. I have a very short one. So I will just share my screen. I hope you are all able to see the screen.
It's a
I
little
think it's
bit
only
going,
showing a portion.
maybe you'll have to zoom out a bit so
Yeah,
that
yeah,
it
just.
fits the screen exactly.
Yes, I hope now that is visible.
Yeah, this is good.
Okay, perfect. Okay. So, I'm much better at dialogue, so I'm going to request everybody to keep the chat box sort of on and keep responding in the chat box to the questions that I will be asking. So the first question that I have for everyone is, what what is it that we what is it that we want to protect? I think some of you have said, you want to avoid mistakes and what's the right use and those kinds of things. But the first question is, for me is, what is it that you particularly want to protect? And I think it's an important question because that will help us answer the question that what is it that uh, uh, is required to be done. So then what are the actions will depend on what is it that we want to protect. I know usually, screens for everyone are off and there are very few people who switch on their videos. But please feel free to switch on your videos. I would really like to see faces and talk with you. But yes, and you're in. So firstly, I hear from Nirali that you may want to protect your intellectual property. Now, I think both these words are very important, and let's remember those words. It's a property. I think that second one is very important. It comes out of my mind. But at the end of the day, it's not it's not only my imagination, it's also a tangible property. So it's a product in some sense. Pramodini has said, my content, my voice, my notation, instruments maybe. Now in instruments, let's say for instance, what do we want to protect there? You know, what is it that we want to protect? Because sometimes, these instruments are traditional instruments. Even notations for that matter could be traditional ones and may have been passed down to us. So what is it exactly that we want to protect? And with that in mind, actually, let us move to the next question, which is, what is the problem with copy? So when we say that we don't want somebody to copy, what is it that we have a problem with? Why do we not want them to copy something? And why I'm asking this question is because that will, again, I mean, actually all these questions somewhere lead to us answering what is the action that is expected. So firstly, what we want to protect, have we identified the material that we want to protect, the property that we want to protect? That's the first thing. The second is that once we've identified that, what is the problem that we have when if somebody copies? Say, for instance, if somebody copies your musical notation or your style of playing, what is the problem that you have? And by that, the corollary of it is actually also that what is then the remedy that you seek? What is it that you want? Because whether it's right or wrong is not really the domain of law. I think the domain of law is to determine what is the remedy that we want. So at the end of the day, law is going to focus on that. It's not philosophy, it's not axiology where you're thinking whether this is right or wrong, whether this is moral or immoral. So the question is, at the end of the day, in law, the question is not going to be about that, but the question is going to be about what do you want. So if we have some reflections on that, maybe can somebody share what what is it? What is the main problem? Is it you feel
So
that it's
people can put it in the chat box, Dakshayani.
yeah, that's okay, absolutely okay. Yeah. Wherever people feel like responding, I mean, more than happy, but I would really like to see the responses so that it's not really a monologue.
You can raise hands, attendees, if you want to speak. We can unmute people specifically.
Yeah. Yeah, so we are at the second question. The question is, what is the problem with copying something? And the corollary of it is that what is the remedy that you expect? Okay. Yes, Neha will do that. Remedy. Okay. Injunction, somebody said. Yes. Okay. So we want to stop people maybe from using it so that whoever is the right creator maybe gets the opportunity to recreate or to actually present their work. And it's rightly acknowledged, maybe. Correct. So that is one of the remedies that we may want. Right. Okay. And please monetary compensation. Yes, Archana is saying that one may want monetary compensation. So that again, I mean, correct. So that's the remedy that we want. And so for now, for that remedy to happen, and these are two very good answers, in terms of what's possible. Now, for those, let's say, two things to happen, what's going to be important is to be able to really actually address the connection between the two questions that we started off with. That what is it that we want to protect, and what is the remedy that we have, and can we establish that this is something that I have originally created, and this is the exploitation, and now this is the remedy that I need. So keep that in mind, and let's move on to the third principle that I have mentioned, which is about control and exploitation. And actually that gives us the remedies that we want. So injunction, for instance, is a way of claiming that control, that this is a piece that I have created and I want to be able to have full control of it. So that's the principle of control. And the second one, actually, the monetary compensation, somebody said. Now that's the other principle of exploitation. So why do you want to control use of something? Is that because you want to exploit it to your benefit? If you are the creator of something, you want to exploit it for your benefit. So that's the principle actually that is here at use. And now what becomes very important in this case, so if you want to control and exploit, then what becomes very important is that you are identified as the person who has created that, say, piece of music. And we are particularly talking about music, so I will use that, but that is true for any other piece of literature or art as well. So now how do you establish the authorship? Who is the author? Firstly, the simple answer is the person who creates. Now, the intellectual property right, if you start reading the law, in the definition, it will give you all kinds of, in relation to an author, it is author, in relation to a piece of, production of sound or a song, it is the singer, or it is the music producer. It will give you all kinds of details. But without going into any of those details, I think the simplest way to remember is that the person who creates, basically whoever is the Brahma, is the one who has the copyright. So And now in that, now when you know that, you are the person who have created this, it will of course get a little complex in terms of music. I think somebody has mentioned, how do you split, copyright between, say, a piece of music which is produced by somebody and sung by someone and written by someone. There of course is going to come that point where we will discuss that. But to simply state that, for you to even have stake in any production, and let's take an example of a song produced for a film. For you to have any stake in that song, what needs to happen is that you should be able to establish your relationship with the product as the creator of the product. Now your contribution to that creation may vary. And that's how one will split the royalties and all of that. That's a different thing. But what you should be able to establish is a very direct connection between the property that you want to protect and your sort of authorship, your connection to that property. So that's very important. And now, the last bit of it actually, which is, what are the types of then rights that sort of you have, So for instance, now you have a property, you have a song maybe, you are able to establish your authorship and your connection with that property. Now you want to sort of benefit, you want to exploit that right that you have in some sense. You want to control and you want to exploit that. So what are you going to exploit it with? What is the right that you in the first place have as a creator? And broadly, I mean, for today's discussion sake, of course, again, the law will give you a list of rights, and there are many, many kinds of it. And I will share some of those as well as a list, later. But I think what is critical for us to understand are performance rights and broadcast rights. And let me take maybe a moment to explain what performance rights and broadcast rights are. So performance rights, you can consider that if I am a musician, have the right to other than what it was created in. Yeah. So, so for example, if I have created a song which has been used in a film, as a performer of that song, I will have the right to perform that piece of music. Now, of course, if I have licensed my right to someone else, if I've not claimed that right in a way, then it basically, all these rights are also transferable like property. So you can also transfer these rights, that's possible. But basically, any creator will have the performance rights to whatever they have created. So that's the first thing. And this includes live performances, digital performances, for a smaller group, for a larger group, in any context. Yeah. So the context here in some sense is immaterial. You have the rights to perform your piece of creation anywhere you feel that. Now, the second kind of rights are broadcast rights. So broadcast rights are rights to stream your piece of content on some another platform. So, and I have picked these two particularly because I feel that they are the ones which sort of we are most confronted with, let's say as musicians or singers or whatever. And what that means is, just a second.
Dakshayani, just a quick question. You need to unmute. Sorry. Your slides are not moving, right? Yet?
No, no, it's on the first one. Yes.
Right. All right.
Yeah. Okay. Yeah. Sorry, I was at the broadcast rights. Now, broadcast rights are rights where you allow somebody, or you yourself can also do that, but you can allow somebody else to distribute your or to present your original creation, say a song that you have created. So you're not necessarily performing live, and so that's separated in performance rights. Whenever you are especially doing a live performance, that's covered in the performance rights bit. Whereas in broadcast rights, what we are talking about is whatever property you have created, let's say in form of a song, you give others or you yourself give the rights to somebody to broadcast it on various different platforms. And by that, especially I think the amendment also in 2012 now in the Indian copyright law also covers uh, any new mediums that may come. Yeah. So I think now creators are protected across various different technological mediums, various different channels, and any new technological sort of adaptations that come along. Yeah, generally. So this is something that one must remember, is that, say, if something new comes, you shouldn't have the question that whether your piece of property is protected or not protected. By default, it's understood that it's protected. So that's the first thing. And now in broadcast, we can in today's times, we can cover radio channels, TV channels, anywhere in that sense. I think even privately, if there are channels where somebody would like to share your piece of music, then that gets covered in broadcast rights. Yeah. So basically, look at it simply as, you have created this property, you have established now your relationship with that property, and now you have the all kinds of rights, like various different kinds of rights related to the piece that you have created, whether you want to recreate it, re-perform it, you want to adapt it, you want to use it in some other fashion, you want others to broadcast it on their channels, you want it to be, heard in a cafe. Any of those instances, you have the full rights for it. So, and now even if you can license all of these, there is something called as a moral rights. So even if you completely waive your copyright, so for instance, you are not claiming copyright on the piece that you have created, you still have the moral rights for that creation, which means that your work shouldn't be ever distorted or misused. So you have the full rights, even if you don't register, even if you don't write this on a piece of paper, it is, even if you have not made a contract on this, and even if nothing of that has happened, as the creator of that property, you have the full moral rights to make sure that that work is not damaged, not, wrongfully used, not distorted in any fashion. So those are, and I mean, and I wanted to lay this as the landscape, this is the broad canvas of copyrights. And let me address um, something that I think was mentioned in the chat box, which was around, how do I protect my expression? Now, why do you want to protect it is a very important question. So that's the thing that we have to remember, that the law will allow many things, but why do you want that to happen is a very important question. And I will share a case study in terms of traditional art forms, traditional forms of music from that point of view. Okay. Yeah. So usually what happens is that we think that it's a lot of work, when we are to claim rights on something, and this is basically, I just wanted to give an idea of where all do you have rights, what are all the locations where any original piece of music that is created has has to be licensed in some sense. You have to take permissions, and you also have to pay the right kind of fees for that. Yeah. And now and we'll see a long list, like a laundry list of things that are here. Yeah. It covers all kinds of locations and all kinds of service providers and all kinds of adaptations as well. So say, for instance, you've done a live performance which has been recorded, and somebody wants to use that live performance in a film. Now the question will come that whether you have the copyright for it or not. Plus then, and for that question, the answer is yes, because you are going to be able to establish a direct relationship with the material. Then the next question is, if Why is that so? Because it's going to be a completely different medium. Let's say it's going to be in a film. But what it means is that if they want to use the exact same piece, then permission is required. If they want to create a new piece, then permission may not be required. So that's very important to remember. So for instance, you've created a song which is fully yours, where the lyrics is yours, where the tune is yours, where you have maybe yourself sung it. It's important to understand that that piece of music cannot necessarily be differently recreated by others. There are some rules in terms of how you can do a cover. You need a written permission of the original artist to even do a cover version. And I think, if I'm not wrong, 50,000 or a certain percentage is the minimum fee that you need to pay to the artist. So those regulations are there. And a new piece can be created and then can be used in a film. But if one wishes to use an exact same piece that you have sung somewhere, then that permission is required. And this is what I mean by, you change time, location, format, space, anything. If you can establish the relationship with the property that you have created, you have the copyright and you can ask for compensation. Now, let me go to the next slide. Yes. I think this was another question that was also there in chat box, because I think this is very important to many of us. I mean, I run an organization called Baitak Foundation, and we use a lot of archival material ourselves. Recordings of a lot of musicians that we listen to, we digitize, we also publicly disseminate that on our website. And we are also constantly faced with this question that, is it right? Is it fair? Is it, that we need to pay someone some compensation and we are not doing so? And I mean, am I defaulting somewhere? That's a very important question, because a lot of the times one may want to fairly also pay artists, but we may not know the modes, we may not know the right people, we may not know where to do that, which are the agencies who can facilitate this for us. So that's a question that comes in often. And so in fair use, these are primarily sort of 5-6 main categories that the law lays out, for which the creator of content has copyright. This does not mean at all that the creator does not have copyright. The creator still has the copyright. The creator still has to be acknowledged and rightly attributed. That is not taken away. The creator still has the moral rights, but the creator need not be paid compensation. So I think the exploitation part that we discussed, that is sort of understood here in fair use as if you're using it for enrichment and research, education, is that enrichment. So using it for that, scenes, or if you're using it for private use, if you're using it at your home, for instance, you're listening to something, then do you need to pay fees to the original creator of that piece? So, and the answer is no. That this is what is covered in fair use. Simply, it's research, private use, education, reporting, review, and criticism. Those are the main things that are covered in fair use. So if you yourself, or even a commercial entity or a foundation, trust, any public entity, is using any piece of music, any recording, anything like that, for any one of this, then you are protected under fair use. I'm sure you must have seen that many websites also mention a disclaimer. And it's important to mention that, because that is how you announce what is the purpose, what is the real use that you're making of the material that you have either shared, or you are either exploiting in your work. Now, another thing that's important to remember here is that even if you're using it for education or research, or criticism or review or anything like that, if specifically the creator of the content has given you a notice to take the content down, then it is the responsibility of the user to take that content down, and that's very important. Yeah. And these are, I thought it would be important. I think some of you have mentioned some of these scenarios in your questions also. And I thought it would be very important to bring up some of these scenarios. And the first is that, do you want to be protected? Are you somebody who are looking for a remedy where you feel that you have not been compensated enough, and do you want that remedy, and do you want to sue? If you want to sue someone, and if you want to go to the court of law asking for that fair compensation or acknowledgement or attribution, whatever that is, then you have the copyright law to your rescue. So that if you establish that connection, then you know that you can present a case for yourself and then receive either that compensation or acknowledgement that is there in the law. The other is that, do you want to be protected from suing? And this is mostly for companies and entities which are using pieces of music. So say if you have an ad running and you are using some piece of music that you feel is just available online, you are not very sure maybe of the rights also, or you don't know where to get the license from. What do you want? Do you want to be protected from suing, actually? And now there are two aspects to this. First is that you have to be well informed about the law. And there are agencies, and I have their names written down. Of course, IPRS, PPL are a part of it. There are some international networks also which do that. In fact, I mean, there are these days also a lot of free music libraries for commercial use from which you can license, or you can even buy music. So that's there. So one is that you have to be very informed about these agencies or companies who do this kind of work. The other is that just be aware of what is fair use. And anything actually that has not been mentioned in those 5 categories is not fair use. So if you are not using a piece of music for research, for education, for criticism, or for review, be assured that there are chances that you can be sued. So those are the only 5-6 categories basically where you are protected. Beyond that, any use, commercial, non-commercial, for that matter, is going to make you liable for whatever remedy that one may require. Yeah. So that's very important to remember. And now let me come to this traditional cultural expression bit, and it's a very confusing area. Also, it's a very, very new field along with traditional cultural expression, especially artificial intelligence and its role in the music industry overall. These two aspects are very, very new and very emerging. So, so there are not necessarily consensus about how one should go, how the law about it and how it should be treated. But I think what's important to understand, and the distinction that I have shared on the slide, is that in traditional cultural expression, I think what we mostly are most concerned about is appropriation of traditional works. Is where, for instance, a motif from Toda community is picked up by Nike and printed on T-shirt without any acknowledgement, of course, of where the design may have originated from. Or, of course, there's no monetary compensation involved. And also, one does not know where this compensation needs to go, because this is traditional knowledge and this is knowledge that has been owned by community. And these motifs have been developed over centuries. So you cannot necessarily establish that link between the property and the creator of the property, because there is no single creator of the property. So now in that case, I think what most communities want as a remedy is protecting the communal sentiment, right, acknowledgement, and also at some point in time, if the community is organized, then economic rights. So in traditional cultural expression, it's very important to remember that if the work is exploited for economic gains, then of course, because it's currently, it will have to go in the court of law. There is no case law, and there is no currently there is no special legislation or any mention of this in our legislation of any kind, or there are no rules as regards this. So this will have to go in court of law, and one will have to interpret the law and see what comes out. But currently, there is no specification around how can either the community be compensated, how can it be protected, how can this attribution and acknowledgement happen. So there is actually no mention in some sense, I would say. One will have to interpret it based on what the current law says. And that actually leads me to the next category that I've mentioned, knowledge versus data. So I think it's important to look at whatever piece of work that you have created, let's say in form of a song, look at it from the point of view of data, because that data can be protected by law. Knowledge cannot be protected by law. And that's actually the connection between fair use, here. Because when you're using for education, when you're using it for research, what you're actually doing is you are using it to further enhance the knowledge. And that actually cannot be protected because knowledge is free. So it cannot be protected. Whereas data, specific ways of organizing things, and a particular kind of property, which is again data, because which will have its unique signature. So that is protected by law. But if it's a traditional, composition, if it is a if it is a composition that has been used in the community for generations, and if we are not sure who the owner is in some sense, then it falls in the domain of knowledge actually. And we consider that knowledge is free for all. And that's why it needs to be open, because that's how the next level of knowledge will be built upon it. So, and that is not protected under law. Only data in some sense can be protected under law. Okay. And this is where I think we could discuss a little bit about artificial intelligence, of course, here. But I think the role of technology is very it's vital, I think, in determining some of these aspects, I think, that we are most concerned about, uh, how do you identify infringement in the first place? I think YouTube is a wonderful example in terms of how technology has been able to identify infringement. So what happens on YouTube is whenever you put a piece of music, you upload it there, when you are uploading itself, it will ask you two types of licensings. So first is a standard license, standard YouTube license, that's what they call, and the second is Creative Commons. So, and I'm guessing most of you would be aware of Creative Commons. Creative Commons is a way of licensing your work. So what you're doing is you are creating that attribution that this is my work, but this is still freely available. And that's why it's called Creative Commons. So it's freely available as long as you have the right attribution. Now, what YouTube standard licensing does is that it's able to identify the fingerprint, the footprint of the material that you have put on YouTube, because it's data and it's coded in some sense, and it creates a content ID. And the moment any other content goes close towards that signature or matches that signature, matches that fingerprint, basically, is flagged as copyright infringement. Now, of course, especially in terms, in cases of traditional songs sung by different people, or songs which originally there could have been instances where the original creator is someone else, but the YouTube song has been created and published by someone else. So now YouTube only will be able to identify what has been put on the platform, not who is actually the original. It does not go to find, because it cannot establish that content ID. So that's there, but that can of course be debated in the court of law. So So unfortunately though, but that's another challenge with YouTube or any other platforms like that, is that they will be able to create that content ID and fingerprint for what has been shared on their platforms and not beyond that. So that's there. But what it beautifully does is that it also notifies infringement. I think another challenge with copyright infringement is that how do you identify, how do you even come to know about infringement, right? Say if I have created a song and it's being played on maybe let's say Bangalore radio, and I may not even be completely aware of it. I may be fully unaware of that something is happening. So how do you control that? Platforms like YouTube or other platforms, also streaming platforms, can notify infringement. SoundCloud also does that. They can notify infringement. Uh, but all the other licensing agencies also, in some sense, do that. So wherever you license, wherever you register maybe your song, that agency is actually also, I mean, they also take that responsibility in some sense. If it is, of course, offered in their services, they will also take the responsibility to notify infringement. And most of these agencies, like IPRS and PPL, will also collect not just your royalties and all of that. So they will of course do that, but if they find an infringement, they will also collect the right compensation for that infringement also. And the other thing that the role that technology can play and also plays sometimes, is that it can actually help establish the circumstances of a case. So for instance, and you have a song, let's say, that was created by X person, and before that person could maybe register that song on any of these platforms or could put it on YouTube, there's somebody else who has gone and put that same song on some platform and basically has registered that entire song on that platform. And has now established that, because now we have technology at our hands. We can do phone recordings, we can do recordings on our laptop or wherever, basically, and or it could even may have been a live session or whatever. If that has been done, let's say, if I have maybe even recorded my practice on my phone, becomes an admissible of your work. And because it is digital, you can establish the date, all of it. So then you can claim that, you were the original content creator. So technology can help us in these spaces, uh, and and technology will look at your piece of work as data. So that's another important thing to remember. Now, how do you get the help of agencies to sort of register your copyright? And is it important to register? If I don't register, then do I not have copyright? So addressing questions like that. Firstly, whenever you create something, you have the copyright. So even a small piece of drawing, even what you speak, even maybe this slide that I've created for these slides for the presentation today, whatever you create, the moment you create, you have the copyright. So that's the first thing. It's not as if it's related to any kind of registration. It's not. If you register it helps you establish your copyright in the court of law. It's much easier, but you are not required to register it. That's the first thing. The next important thing is that there are various different agencies who, like IPRS, who you can become a member of. In some sense, they are private bodies. They're not government bodies, but they now companies and privately do this as business. Is that they can register your piece of music, and they have different kinds of licensing that they offer. So you can choose what kind of licensing your work you want to be made available for. For instance, I may not want my song to be played in cafes. If I am of that opinion, I can choose. I don't want that kind of licensing, but maybe I only want sort of radio or television broadcast kind of license. So all of that, you can choose what you have to fill forms and all of that, and you have to make sure that they know what you are okay with and what you're not okay with. And then these agencies should basically help you monitor and regulate, if there's infringement or so. Now, to be honest, I haven't personally worked with agencies, but what I have heard is that it's very difficult to be able to identify infringement. Also, it's very difficult, especially for smaller creators, for individual creators especially. So if you are, if you're not a big conglomerate and you're not, or you're not a big musician who has a fan following, it's very difficult to really get that attention and to really get the right kind of remedy that you are expecting. But I think this overall as a field also is a very emerging field. We all hope that, with better laws and with better demands from public, of course, maybe they will change over a period of time. So yeah, so that's possible. But yeah. Yeah. And this is, the law is very simple in that sense, I think, and why I have not gone necessarily into describing or just sort of reading out from, what the law is because what happens is that we sort of get taken away, or we also sometimes maybe get even intimidated by the use of words and long sentences and all of that. I think that's not required, but if you want to further read, of course, a lot of these things are available on various websites, government documents. There are nice summaries also. So one can, of course, read that. But what's very important to remember is are those 2, 3 things that I mentioned at the very beginning. Is that firstly, understanding what you want to protect, why you want to protect it. Then if it is really a property, can you identify the uniqueness of that property? Can you establish your relationship as the creator with that property? And then are you sure of what remedy you really want? So I think those are the few key things that are very important. Yeah, so that's about it from my end. I think now I would like to maybe specifically answer your questions so we can have some time for that. Yeah.
Actually, there was one question on about AI generated music and copyright.
Sorry, I must have missed that. Can you read it, or I'm also just scrolling and trying to.
Yeah, how can we handle AI generated music and copyright?
How can we handle? Okay, so so for I think I very briefly mentioned, but it's a very new field. I don't think anybody really has a very conclusive answer to that question. But I will share a few perspectives that I have read about and heard about. One is that there are many, and I think all these organizations that I have mentioned here, especially the International Confederation of Societies of Authors and Composers. These organizations are also lobbying organizations who are trying to see what new laws can be brought in. And one of the things that they speak about is that with AI, the problems are at multiple steps, actually. The first is at AI, training the AI itself. So for instance, whatever is available in public domain, and frankly, not just under Creative Commons licensing, but whatever has a digital footprint, whatever can have a unique ID in that sense, AI is actually being trained on all of that content that's available on the web. Now, there's firstly a question around, and it's a very ethical question, actually. It's around that, can that be done? And currently, I don't think that there is a legislation that at all talks about that, it cannot be done. Of course, there are cases emerging and there are artists who are saying this, that, the AI shouldn't be trained on my work because I haven't given that permission. And I'm hoping that more regulations will come. But that's the first challenge, actually, in training AI itself. When music, let's say online music is being used to train AI, have we as creators given that permission? That's the first. I think the second important question is around, say, if I have created a piece of music already, and if some tool maybe is changing parts of it, using parts of it, modifying parts of it, then is it fair use? I think that's an important question that comes in, right? will it fall under fair use? I mean, can we consider that this is education? Can we consider this is research? Now, that's a question again. I mean, it's a question that is being debated. Is that okay? The other is that when AI generates music, who is the owner? And I think that's a question that has been fairly asked in all in some popular instances. I think that's one thing that we have read, is that at the end of the day, um, AI is also at the end of the day owned by some company. So now, if that's the relationship, then who is to receive the compensation, the economic gain, the exploitation? Who is doing that exploitation? So who is to receive the products, the eventual products, and the profit of it, in a way? So they are actually all very tricky questions, but they're still being discussed and debated. I think what's very important is that those questions are asked, that kind of lobbying is done, that kind of putting forward views of artists and collecting those opinions and sharing those with lawmaking authorities. If an amendment is to come out, then, actually giving these suggestions. I think with AI, we are at that stage somewhere. There isn't a very clear answer to it. But there are challenges at every step, right from developing AI to actually AI creating its own music.
Sure. So as we take more questions, my colleague Vedang, he has pasted the feedback link in the chat box. I request all of you who are attending the session to kindly give your feedback for the session and also your suggestions for what kind of topics or any improvements that you wish to have. So yeah, if there are any more questions, you can also feel free to raise hands. We will unmute you to take questions. There was one which I thought, like, if you can like summarize some of the common mistakes that artists make when they are protecting their music rights, how they can avoid it.
Okay. Yes. Okay. I think one of the things the artist can be you do, and like I mentioned, we now have technology, and we should really make some good use of it. And that is something I feel artists can really leverage very well. So firstly is that whenever, maybe if you're coming up with an original idea, a song line, a lyrics, or anything like that, in that sense, I would say document it, because that documentation can establish your connection with the work. So it's very important that we start documenting ourselves. That is one. I mean, that's just I mean, I feel that's important. You may choose to, of course, not document yourself, but I do feel that that can help us establish ownership. That is one. The other thing that needs to be done is that if you're working in any commercial setting, especially, or even for that matter, pro bono, but wherever you feel your work is going to be used, I think it's very important to at least bring this in the conversation. That, is there a contract? Is there a licensing? Is this going to be freely available? Is this commissioned work? Is this something that I create, but then I completely give it to whoever has commissioned this work? Is it of that kind? I think these are some important questions to ask. So I think the list there, you could ask 3-4 questions. So firstly, why do you want to create, say, a piece of music? Will it be used commercially, non-commercially? So now you know that there are at least 2 categories, right? One category of fair use, where it's fully educational and research, all of that, whereas the other is more for exploitation, for economic gain. So if you know now that, let's say, your pieces of work is going to be used for economic gain, can you ask that question of, whether this is fully commissioned work, whether you're going to get fully paid, and then you hand over your piece of work and you sort of, I would say, you give away your rights completely to whoever has commissioned that work, or you're still going to, it's at maybe a very lower fee, and you are still going to hold the copyright to it. So ask this and see if, and there are actually very standard licenses and standard contracts that are easily available even online. So one could make use of those, write it down, on a piece of paper, on a thing is very important. I think what happens is that most of the times we also keep our communication verbal. We may do this in a meeting and all of that, but I think it's important to maybe even quickly summarize this and put this on an email. These would be some best practices to follow. And also making sure that, say, if it's a work that you are going to create, you should have copies of it. I think that's another very important thing for a creator. So you've created a piece of song, let's say for someone, or you're licensing it to someone for use. It's important that you have the original copies of it. I think that's another very important thing. Is there any question that I have not answered? Yeah.
And there was one on the digital platforms. Any specifics on the licensing agreements with digital platforms?
So I think it's very popular now, not that I need to mention, but a lot of these platforms are not fair in terms of their agreements with artists. Of course, a lot of artists have spoken against some of these platforms also. Now, there is a difference. I see that question. There is and I will make a distinction in that. There's a difference between YouTube and Spotify and Instagram and TikTok. YouTube and Spotify specifically, for instance, they are more subscription based. They can and they do charge their users, and then they will pay you a certain kind of royalty. That's the category that they fall in. Whereas Instagram and TikTok more fall into the consumer applications, and there's no real fee to you. You don't subscribe to it in that sense. So there is no monetization that happens instantly just to be on the platform. So that's one major distinction there. Now, in Instagram and TikTok, when you are using the applications themselves, like the terms of agreement, if you read, that itself has some of these rights that you share. And for specific videos that you create or so, you will see that there are various different tabs. If you don't want somebody to use this as openly as you would want, someone else may want, you don't want it to be remixed or whatever, you can switch off those settings. So that's a different thing in a way. But whereas YouTube and Spotify will have standard licensing in that sense. Now, of course, I mean, they are bigger corporates in a way. It's a little difficult to be able to negotiate contracts or negotiate those terms of licensing. So it's extremely, extremely difficult. I think even really big artists find it very difficult sometimes. But yeah, so that's there. But I think we have agencies like these CD Baby or distributors basically, who will make sure that whatever is the standard licensing, you are compensated through that. So that's done. So there are, of course, distributors as agencies who take care of that. I think at least on these platforms, the distribution network and the clarity around that exists. So you can just go to say, I'm just taking CD Baby as a name, but there are some others also. You can go to a company and you can say, hey, this is my piece of music, and now I want you to distribute it on various different platforms. And then that CD Baby will take care of basically all kinds of licensing, and they will make sure your royalties come to you and all of that. So that happens. Yeah.
Yeah, so thank you, Dakshayani, for I think we have covered almost all of the questions. In case we have missed out any, would you be okay addressing them over email separately?
Yes,
in case you have
absolutely. I'll be
questions?
more than happy to do that. Yes,
Yeah.
absolutely.
So let me remind everyone about the feedback link once again. I'm sure you have all enjoyed this session by Dakshayani. And also, let me take the opportunity to announce the next session in this talk series. So our next session is going to be a back-to-back session, first on 8th of October and then immediately on 15th of October. And both the sessions are going to be addressed by Ameya Kunte, who is a CA by training. It's a two-part series on ESOPs and SARs, which Ameya will be addressing. So we will be, of course, reminding you over WhatsApp. The WhatsApp link will be shared to you for joining the WhatsApp group. Also, you will get an intimation over email for the upcoming talks in this series. So thank you once again, Dakshayani, for this wonderful session. And I guess it was a very interesting topic and very skillfully handled by you, I must say. Thank you so much.
Thank you so much. It was really a pleasure to be here. And I'm happy, very, very happy that I could do this. And I would be more than happy to engage with anyone else at any other point in time as well. Thank you so much,
Thank you.
everyone.
Thank you. Bye. See you.